All right, shall we start?
Vamos a... Déjame
Buenos
saludar,
días,
presentarte y comenzamos. Buenos días a todos, ¿cómo están?
¿cómo están?
Hola, buen
Bienvenidos.
día. Está Gabriela.
Les recuerdo ponerse pueden escuchar en el canal en inglés directamente al profesor Busás o conectarse en el canal en español abajo en la opción de traducción, ¿sí? Es importante para elegir el canal correcto. Tienen que estar en uno de los dos, tienen que ver español o inglés según lo que elijan. Bien, como la clase hoy estamos de a dos, perfecto, ahí vi quienes están de a dos desde la oficina, gracias por avisar. Bueno, voy a comenzar haciendo una presentación breve del profesor Busás y luego ya lo dejo que comience su clase. Como ustedes saben y como habíamos comentado, el profesor Soltán Busás estará a cargo del módulo Justicia, ética y derechos humanos en las políticas públicas. El profesor Busás es profesor de la Universidad de Notre Dame. Es el segundo año que Soltan está acompañándonos en el dictado de este módulo. Es un experto en derechos humanos, en derecho de políticas internacionales, en relaciones internacionales, y es profesor de Asuntos Internacionales en la Universidad de Notre Dame. Así que para nosotros es un gusto, estos años ha sido un gusto tener a Soltan como docente, y sobre todo porque además es bueno poder hacerle todas las preguntas que consideremos con esta mirada sobre los derechos humanos y la interacción con las políticas públicas en términos del acceso al agua. Así que, Soltan, el micrófono es tuyo y muchas gracias nuevamente, y también será bueno escuchar de ti tu experiencia y para que puedas interactuar con nuestros participantes este año. Muchas gracias.
Thank you very much, Gabriela, for the kind introduction. It is a pleasure to be here. Thank you for the interpreters, and let me know if I speak too fast. Hopefully this pace works for everyone. Thank you for coming. I'm excited to interact with you. I understand that many of you have extensive experience working on water-related issues, which could certainly result in rich conversations. So today, my plan is to talk a little bit about water rights, as you'll see on the next slides. But I don't need to tell you, obviously, water is really important. And here are a few quick examples. When you think about your own water usage, moving from the top left picture on the screen, you can see that as individuals in our everyday life, we use quite a bit of water for our daily needs. Moving to the next picture, we also know that access to water and clean water and sanitation cannot be taken for granted. Unfortunately, over 1 billion people in the world do not have reliable access to safe drinking water, and over 2.5 billion people in the world do not have access to water that is needed for various sanitation-related uses. So recognizing the importance of water and the fact that many of us do not have access to it, the UN is organizing various conferences trying to give the issue more attention. The latest big conference was in March of this year. In the US also, water-related issues are receiving more attention. There's increasing concern about how fracking, for example, has been depleting our groundwater reserves. There's also a problem with clean, safe water, as you may have known in various parts of the US. like Flint, Michigan, or Jackson, Mississippi, and elsewhere. So clearly, water rights cannot be taken for granted. So here's the roadmap for today. First and foremost, we're going to talk about how water became a right. We tend to assume that, yes, water is a right, but there's a story behind how the way water became a right. So more specifically, we will talk about conceiving of water as a human right as opposed to something else, such as an economic commodity. We will talk about how water became a human right based on the Reiner's journal article. And then we'll talk about the nature of the human right to water. What are exactly the obligations that are involved? And then at the end, I would love to have a conversation with you about some of the challenges of implementing water rights in practice. And I am sure you have a lot of experience there. And then next class, we will talk more about the challenges and opportunities of translating the human right to water from the legal framework that aims to guarantee that right to actual policies, to making sure people enjoy their right to water. And then I will also briefly raise the question of whether water itself should have rights. And I will have more to say about that next class. All right, so let's start with how water became a human right, how we conceive it as a human right. And there are two kind of dominant models to look at water. One, which is one is an economic commodity, right? That's on the right of your screen. And this simply focuses on individuals as customers. We have access to water through money, right? And so this also means that because we have different amounts of money, our access to water will be unequal. It also means that our access to water is alienable, meaning it can be taken away if we do not have the money to pay for it. In terms of who provides water, this model focuses on private companies as the main service providers. An alternative model that focused on human rights, and of course there's overlap between the two models, but for purposes of analytical understandings, we will distinguish between the two. So water as human right focuses on individuals not as customers, but as right holders. What does that mean? It means that we are entitled to water through our humanity, right? It doesn't, our access to water should not depend on our money. So we all are equal in terms of human rights. That means we should have equal access to water. And second, our access to water is inalienable, meaning it cannot be taken away from us, right? We are entitled to water just as we are entitled to other human rights. And this approach of human rights, or water as human rights, focuses on states as the main duty bearers, right? Is the state that is there to ensure that people's right to water is satisfied. Now, you could think of pros and cons of each model, but I wanted to put these two on the table. And we're going to focus on how the right, or how water as a human right, that is the model on the left of your screen, has become dominant in many parts of the world. And to understand how this happened, we have to go back to the very beginning of the story, which happened kind of in the wake of World War II, right? So 1945, the decision makers from various countries are trying to build a new international order. They put the foundations of various new international organizations and laws. And one thing they do in this post-1945 period is they also engage in a sustained effort to put down the foundations of an international human rights system. And a key element of that system is the Universal Declaration of Human Rights. We're actually celebrating its 75th anniversary this year. So it was promulgated in 1948. And what you see there in terms of what rights are enshrined in the Universal Declaration is that one thing is missing. And that one thing is of special interest to us today, which is the human right to water is not there, right? You could potentially link it to things like Article 3, the right to life. You can certainly link water to that. Or number 25, you can link the right to water to adequate living standards. But the point is, in 1948, in this document, the right to water was not explicitly mentioned. So that brings us to the big question of how did water then become a human right? And that is the story that Reiners tells in the article that I recommended to you all. And that her story focuses or centers on the role of transnational advocacy networks. So these are groups of various actors. Some are non-governmental organizations, some are individuals, some there can be other organizations that partner with them, and they are transnational, they cross borders, and they are united in their advocacy of a certain issue, right? In this case, their advocacy for water as a human right. And these members of the Transnational Advocacy Network, many of them NGOs, non-governmental organizations, they made development-related arguments for the importance of water as a human right. That was important for development, and they raised concerns about the affordability of water. So if we conceive of water simply as an economic commodity, people might not be able to afford it. And so they pushed for water to be seen as a human right. Now, there was some pushback against this approach from others who prefer a commodity-based approach to water, emphasizing that would be more efficient, and so emphasizing the advantages of seeing water as a commodity and raising concerns that if you see water simply as a human right, that would be wasteful and so on. Okay, so what were some key events through which water became consolidated as a human right? In 1977, at the United Nations Water Conference, the Mar del Plata Declaration was produced, which explicitly mentioned the right to water as a human right. In subsequent conferences, this approach was consolidated and broadened to even include not just the right to water in terms of the right to drinking water, but also the right to water for sanitation purposes. So the 1992 UN Conference on Environment and Development in Rio was important in this respect, as well as the 96 Habitat 2 conference in Turkey, in Istanbul. And then finally, I would mention here the 2003 Third World Water Forum. And the reason why this was important is that it served as a trigger for the Committee on the Economic, Social, and Cultural Rights to issue a general comment. So this is a committee that is in charge of implementing and interpreting the International Convention on Economic, Social, and Cultural Rights. And from time to time, their mandate allows them to issue so-called general comments in which they can clarify, they can extend various articles of the International Convention. And this is exactly what they did. So their general comment 15 is really crucial to understand how water became a human right. Various transnational advocacy networks saw a link, they saw a connection between their advocacy for water to be recognized as a human right, and the International Covenant on Economic, Social, and Cultural Rights. So this covenant actually included a number of articles that transnational advocacy networks could use to advocate for water to be recognized as a human right. The most important article, I would argue, was Article 11, Paragraph 1, which stipulated as follows, I quote, "The state parties to the present covenant recognize the right of everyone to," and this is especially important, "an adequate standard of living for himself and his family, including adequate food," and then went on to say, "clothing and housing, and to the continuous improvement of living conditions." So the General Comment 15 basically linked the right to water to this recognition of the importance of adequate standard of living. And they said, if adequate food was mentioned, and housing and so on, this was not a list that was exhaustive. This was a list just giving examples of what it means to have an adequate standard of living. And just as adequate food is necessary, adequate water is also necessary. So just because the right to water was not explicitly mentioned, it doesn't mean that the drafters did not intend it to be there, right? So they basically, what the Committee on Economic, Social, and Cultural Rights did was to say, there are some legal bases for recognizing water as a human right. It's true that the Universal Declaration on Human Rights did not explicitly mention water as a human right, but that doesn't mean that it wasn't implicitly there, right? Just like adequate food was there, we could extend that article to cover adequate water. And in addition, they also pointed to subsequent treaties which do mention water in one way or another. So for example, the Convention on the Elimination of Discrimination Against Women, Article 14 mentions in connection with adequate living conditions, the importance of water supply, as you can see underlined on the slide. Similarly, the Convention on the Rights of the Child, Article 24, talks about adequate nutritious foods and this is key, clean drinking water, right? And then finally, the committee also pointed out that in its dialogue with member states, that is, states that signed the International Convention or Covenant on Economic, Social, and Cultural Rights, in dialogues with these member states, because the member states are supposed to submit a report about their compliance with this covenant every few years, and then the committee can engage in conversation with them about how well they're doing. So the committee pointed out that in past conversations with member states, the right to water was also discussed, pointing out that actually member states already agree that the right to water is covered by this covenant. So overall, then General Comment 15 argued that even though the right to water was not explicitly mentioned in the International Covenant and the Universal Declaration on Human Rights, it should be covered, just like other things that are necessary for adequate living standards are covered, right? Opponents, however, contested this and said, this is actually inventing a new right. This is not, this is beyond the mandate of the committee, and they're just making themselves into lawmakers, which again, they should not be doing. Supporters of their interpretation in General Comment 15 were arguing that the committee was not inventing a new right. Instead, it was simply making an old existing right explicit, right? So you can think about where do you stand in this debate. If anyone wants to jump in and share your thoughts about which side you you lean toward, that would be great. If not, I'm happy to move on as well. But I will pause for a second to see if you think that the committee invented a new right or simply made an existing right explicit. You can raise your hand and jump in, or if not, we'll move on to some other questions. But at least this is something that you can think about, even if you do not actively engage with this question. Okay, so let's move on then. The consolidation of human rights to water has continued after General Comment 15. So in a variety of ways. One was that between 2005 and 2015, there was at the UN the International Decade for Action called Water for Life, which further, again, consolidated this notion that water should be seen as a human right. In 2010, the United Nations General Assembly passed the resolution that was called the Human Right to Water and Sanitation. So there, water was broadened, not just as something that is necessary as a drinking water, but also needed for sanitation purposes. Subsequent treaties also incorporated the right to water as a human right. For example, the Convention on the Rights of Persons with Disabilities stipulates the human right to water. And then, of course, over 50 states accept the right to water domestically and enshrine this right in a variety of legal and policy documents. And finally, there are also a number of court rulings, semi-judicial ruling or quasi-judicial rulings that recognize the right to water. And one would be the Naidenova versus Bulgaria a ruling, which is not a legal ruling because it was not issued by a court, but by a quasi-judicial body, which was the Committee on Civil Political Rights, and in 2011, and they recognized the right to water as well. All right, so did you have any thoughts about the Nina Reiner's piece? If you did, I would love to hear from you about that. If not, again, we can move on. But basically, our conversation so far largely built on that Reiner's article in terms of how water became a human right. So I was curious if you had any reactions to that article, if you read it. So I will pause for a minute. If you want to jump in, please do so. Raise your hand, share your thoughts. If not, we'll move on. Yes, I see Alfredo's hand.
Sí, hola, ¿me escuchas?
Yes, I can.
Bueno,
Thank you.
un gusto, Zoltan. Bueno, estoy aprovechando unos minutos de esta charla. De lo que pude comprender, entiendo que lo que se ha logrado es hacer más explícita el derecho y no crear un nuevo derecho. Es como que anteriormente estaba más, era más general y menos definido, no solamente en esto, sino en otros aspectos también. Por lo que a veces, por lo que se hacía necesario puntualizarlo en el agua y en otras cosas. Por lo menos así lo interpreto. Muchas gracias.
Thank you so much, Alfredo, for jumping in and sharing your thoughts. It is much appreciated, and I think most human rights advocates, of course, would agree with you. So thanks. And I know that there are some online comments as well. I saw Guillermo commented as well. So thank you for that. And apologies if I... Yes, please. Mm-hmm. Great. Thank you so much, Guillermo. And apologies if I ever miss some of the online comments.
No, you're fine. You haven't missed
Great.
any comment.
All right. Great. So so far we talked about how water became a human right, but we didn't really talk much about what exactly is the nature of the human right to water. That is, what are the obligations? What is more specifically, what are the specific duties, obligations that are involved? Right. And so we're going to talk a little bit about that, focusing mostly on the human right as it appears in legal documents. And then toward the end of the conversation today, I would like to shift towards some of the challenges and opportunities in terms of implementing those rights. That is, translating them from the pages of legal documents into practice. And we will continue that conversation in our next lecture as well. So we will just start that conversation. Okay, so what is the nature of the human right to water, right? What does it look like? The content of the right to water includes a number of rights and correlative duties. Often these are categorized as kind of as negative and positive, right? So negative aspects or negative rights basically just require the states to stay out of people's business, right? And don't harm their access to water. So don't pollute the water, don't destroy water facilities and infrastructure and so on, so that people can enjoy their freedoms, their right to water. The positive aspect of it pertains to entitlement. So there, it's not enough for the state to just stay out of people's business, but it has to go a step further and has to do something to make sure or to assist in people enjoying their rights. And we will go deeper into some of these issues. So what does it mean for people to have adequate water rights? There are a number of dimensions that must be satisfied. One is water must be available, right? The availability of water. If not, then you cannot enjoy your right to water, even if legal documents stipulate that. Two, it also is important to have good quality water, right? It's not, if you have water that is contaminated and polluted and it's not safe to drink, then you cannot have adequate enjoyment of water rights. It's obvious. Third, water has to be accessible. And you can disaggregate the concept of accessibility into multiple dimensions. First is physical accessibility, right? It cannot be too far from you, because then it's very hard, if not impossible, to enjoy your right to water. Two, there's economic accessibility. In cases where you have to pay for water, the price cannot be so high that people cannot simply afford it. Third, the access to water has to be non-discriminatory. It cannot be the case that some people, some groups have access to the water, but others do not, right? And then finally, there's this concept of information accessibility. So can someone tell us what that refers to? What is the role of information in making water accessible? What do we mean by that? Does anyone want to jump in? Okay, if not, I'll simply, for the sake of time, clarify that. So that just simply means that people know about water, like where are the safe water sources, and making sure that information is widely available. People are informed, right? So that's really important too, because otherwise, if we don't have the necessary knowledge in terms of enjoying our right to water, then it becomes hard to do so. Okay, so what are the state's obligations? What sort of obligations can we talk about? And the reason why we focus on the state is not that other actors should not be attributed obligations in people's enjoyment of human rights, and specifically the right to water, but because the international human rights framework makes states the main duty bearers, right? The states are the main actors who are supposed to ensure ultimately the right to water, even if often specific details are delegated to other actors, such as private companies. So we can talk about, in terms of what the law says, the first category is general legal obligations, right? And there, the notion of progressive realization is key. So the law, just like for other economic, social, and cultural rights, says that states are obliged to ensure that people have the right, human right to water, but those obligations are conditional on the state's capacity, right? What's the financial capacity of the state? What sort of administrative capacities they have? Because we know that even when the political will is there to provide people with the right to water, sometimes the state lacks the necessary capacity to make sure that the water infrastructure is in place and in working order, and so on, right? So because of this, the international human rights legal framework asks states to do their best, basically, right? But it places the bar differently for different states depending on their capacity. Now, that said, there are also some immediate obligations that states have to fulfill regardless of their capacities. And that is, for example, the non-discriminatory access to water, right? So that's something that immediately must be satisfied by all states, regardless of their capacities. And that's not the only one. Okay, so moving on to more specific obligations, legal obligations. We usually talk about three legal obligations. One is to respect people's right to water. One is to protect these rights. And then third, to fulfill these rights to water. So what does it mean to respect people's right to water? Claudia, do you want to jump in? You might be muted because we cannot hear you.
Hola, buenos días, ahora sí. Un gusto. Consulta, yo soy una alumna que pertenece a Chile, soy chilena, y en el año 1980, producto de unas circunstancias políticas que vivía en nuestro país, se generó y se creó el Código de Agua. El Código de Aguas en Chile señaló que el Estado de Chile concedía los derechos de agua de los cauces superficiales y subterráneos a cualquiera persona que lo solicitara. Y posteriormente estos pasaban al conservador de bienes raíces y los inscribían a su nombre, a un nombre particular. Esto generó que a partir del año 2000 y en adelante se dieran cuenta de que la Dirección General de Aguas que había muchos derechos inscritos a particulares, ¿ya? Y que estaban, que superaban en cierta manera la cantidad de aguas de los cauces subterráneos y superficiales. Por lo tanto, actualmente en Chile se modificó el Código de las Aguas el año pasado, antes pasado, hace unos años atrás, hace pocos años atrás, señalando que es un derecho humano al agua. Pero tenemos que en Chile casi todos los derechos del agua son privados. Y es más, dado la crisis hídrica que actualmente cruza nuestro país, muchas de nuestras regiones, muchas regiones están, se ha cerrado las cuencas, no se permite ni no se puede solicitar más derechos de agua, y tenemos problemas de escasez hídrica y problemas de generar y entregar agua a las localidades rurales, sobre todo, producto de que no tenemos derecho de agua y no podemos darle derechos de agua a estos comités de agua potable rural. ¿Cómo eso se relaciona con estos artículos o cómo se puede llevar a cabo una modificación en el Estado, siendo que se ve el derecho de agua como el derecho al agua como igualitario, como un derecho humano, ante la situación que tenemos en nuestro país? Por ejemplo, ¿cómo el Estado puede o cómo se puede concebir esto dentro de las obligaciones del Estado, siendo que ya muchos derechos son privados en Chile? Ya hay incluso se generan se paga por esos derechos de agua para poder obtener agua. En muchas regiones que tenemos que pagar por ello, la sanitaria urbana, tanto como en las localidades rurales. Eso. ¿Cómo se subsana eso?
That's a really good question, Claudia. Thanks for sharing. And that points toward what I want to discuss mostly at the beginning of the next session, but also at the end of today's session, which is implementation, the question of implementation, right? Right now, we're talking about what water rights look on paper. And what you'll notice is that the international human rights legal framework is very broad, right? It tells you these are the rights, these are the obligations. But then when it comes to translating those obligations to practice, such as in cases of the issues you mentioned in Chile, where there can be a lot of complexity in terms of how you deal with that satisfying people's human right, because you have to think about your right. Private actors, the right to property, you have to think about the water scarcity, various claims to water. So how do you make sure that the right to water is enjoyed by people in a fair and equitable and reliable fashion? And so I'm gonna approach that sort of issue very humbly. I do not have an answer for you, because to answer it, you have to know all the local complexities and issues. And so these are the issues that are often decided in various legislative bodies, or they are fought over through litigation processes, right, in various courts. And they will have to take into account what are the state's international human rights obligations, what are various legal provisions saying, and then they have to rule on these issues, right? Domestic courts often. And if the parties involved are unhappy with the rulings, then you can take it up to various international courts, including international or regional human rights courts, right? So these are really tough issues. And so I'm hoping that we can come back to your question and similar questions at the end of today's session, when we talk about, okay, this is what human rights to water look like on paper, but how do we move from there to practice, to the really thorny practical questions, one of which you very nicely brought up. So thank you for that. So just to finish this conversation about what human rights to water look like on paper, I want to just go through the specific legal obligations as well. So states have to respect the human right to water. What does that mean? That often refers to the state not interfering with people's enjoyment of those rights. So again, the state has to refrain from polluting the water, from destroying infrastructure that is necessary to get the water to people, right? To protect human rights to water, the next specific obligation requires that the state goes a step further and also makes sure that third parties do not interfere with people's right to water. So that means, corporations or other individuals do not engage in polluting the water, diverting the water, destroying water infrastructure, such that people cannot enjoy their right to water. And then finally, there's the state's obligation to fulfill, which means going even further and taking positive measures to making sure that individuals have the right to water. So, for example, the state needs to maintain water infrastructure, repair water infrastructure, improve it as necessary, have a good national action plan in place, a strategy that allows long-term thinking to the sustainable use of water. So all these need to be done by the state. It's not enough for the state to just sit back and say, look, we respect people's right to water and do not pollute the water. No, the state also has to often go further than that, right? And that, what does it mean to fulfill the right to water? That can be further disaggregated into facilitating, promoting, and providing water, which General Comment 15 discusses, so I will not go into that detail now. Okay, moving on, there are also international obligations that states have, and this is what you often see when states interact with each other. So the River Nile, for example, there are various kind of international frictions over that between Egypt and some of its neighbors, but there are many similar examples across the world where rivers or large bodies of water that cross state boundaries are fought over by different states, and these states have an obligation to make sure that they do not, for example, if we talk about the river, do not exploit the fact that they're, higher on the river so that they build dams, do things that rob downstream states from enjoying their right to water. And then there are also a number of core obligations, very kind of specific obligations that states have. Again, these are listed in the General Comment 15 that was issued by the UN Committee on Economic, Social, and Cultural Rights. So I will not list them. You can find them online. You can find them in these documents. And so I now just want to talk a little bit about violations. So what does it mean to violate international human rights given the international legal framework? First, we have to distinguish between states' inability to, make sure that people have and are able to enjoy the right to water, and unwillingness to ensure that people have a right to water. Right? When we talk about the first one, inability, that is, states might want to do everything they can to ensure that people can enjoy the right to water, but they might not have sufficient capacity, right? When we face situations like this, usually we do not talk about states violating people's right to water, because again, remember that notion of progressive realization. That means that international human rights law expects states to carry out their obligations within the constraints of their capacity, right? And so if they're not able, usually they're not seen as violating necessarily the right to water, or the approach is different in that instead of punishing a state like this, the idea is to build up its capacity, try to provide capacity and know-how so that those states can help people enjoy their right to water. If you face situations where a state is unwilling to allow people to enjoy their right to water, that's totally different. Those are kind of willful violations of international human rights law, and there you can have some sort of sanctioning, enforcement, and so on. Of course, in practice, there's a bit of a difficulty distinguishing between these two, because a state that might be opposed to people's right to water and unwilling to ensure it might try to hide behind discourse on inability, right? Might say, we would like to ensure people's right to water, but we don't have the capacity. So in practice, the distinction can be fuzzy. Okay, and in terms of violating obligations, again, just because we talked about specific legal obligations to respect, protect, and fulfill people's rights to water, violating any of those would count as violations under international human rights law. So here, I want to see if you have any thoughts about General Comment 15, if you read it. And if not, I would like to move on and talk a little bit more about implementation, following up on Claudia's earlier question. And I would love to hear what the rest of you think about that question and other issues about challenges to implementing these international human rights law provisions about the right to water. But first, I want to see if you have any thoughts about General Comment 15, which made the right to water explicit. And if not, we can move on to the implementation question.
I think Alfredo has his hand raised.
Sí, perdón, si no hay otro, quisiera hacer una pregunta, ver si es posible volver un par de diapositivas para atrás, una o dos, donde están las condiciones iniciales. Ahí. Uno de los inconvenientes que yo veo, si dejando de lado la complejidad de lo que mencionaba la compañera, de lo que pasa en Chile, que ya requiere de cuestiones legislativas mucho más complejas, yendo a la práctica, hay asentamientos poblacionales históricos, entiendo que en los diferentes países, y acá en Argentina, donde la posibilidad de acceder al agua se vuelve muy compleja, y en esto la gente de El Chaco, no sé si están, pero han trabajado mucho. Lo veo ahí Horacio de La Rioja, donde ahí ya tienen dificultades bastante graves. No sé si tienen esta situación de localidades que realmente, digamos, demandan este servicio, se expone como derecho humano que lo es, pero hay una imposibilidad fáctica para poder llevarlo adelante. ¿Hay algún comentario, si tienes algún ejemplo de cómo se ha resuelto esto en otros lugares? Gracias.
Thank you, Alfredo, and sorry for not calling on you earlier. I thought that you just forgot to put your hand down after your previous question. That's a great question, and those
No
are
hay problema, no hay problema.
Those are really hard, right? What do you do when there's an inability? Maybe there's not enough capacity to realize water rights. So it depends on what are the roots of inability. where does inability come from, right? And I don't know this specific case, so I can talk about this in general terms. If the inability has to do simply with, you know, the state not having enough financial resources, know-how, people who would actually, you know, build, maintain water infrastructure that is adequate, in those cases, other countries or international bodies can step in and provide some degree of know-how, can provide knowledge about best practices, can provide experts who can, you know, help build the required infrastructure, right? But or if we're talking about financial resources, there can be advantageous loans, and maybe, you know, donor countries or international organizations can step in to provide financial resources to make possible for people to enjoy their rights. If that inability simply comes from, you know, water scarcity, there's just not enough water, right? Demand far outpaces supply, then that can be difficult too. You have to think about whether it's possible to change water consumption patterns, whether water could be brought in from elsewhere, or what is the solution. And to really answer questions like this in an intelligent fashion, you have to really know the local landscape of complex issues, which is why I think, which is where your expertise comes in, because many of you have expertise in these issues and have worked on these issues. And that's why I wanted to have this conversation with you about, you know, how do we move from, okay, we have all these human rights laws and stipulations about the water rights, but how do we move from there to actually people enjoying those rights in practice? And we can talk about, you know, national legislation, water strategies. You can talk about local and regional policies or national policies. We can talk about what indicators and benchmarks should and are used, and what to do about remedies, right? It's great if a court rules in favor of someone who needs to have his or her water rights reestablished, but the court itself cannot carry out those needed measures, right? So again, we need a lot of professionals at the local level, community members, and others working together to make these things possible. And which is why I'd love to hear about your thoughts about implementation and how, in the circumstances that you know, we can best move from the letter of the law, which says we are entitled to water as a human right, to actually making sure that everyone enjoys water rights. And I'm gonna turn it over to Claudia now, but thank you, Alfredo, for the probing question.
Hola, buenas tardes. Otra duda que me asaltó fue cómo el derecho al agua se puede, está asociado a comunidades indígenas, por ejemplo. Porque la comunidad indígena, las comunidades indígenas o las asociaciones indígenas, porque ellos, las comunidades, tienen una cosmovisión distinta del agua, lo ven asociada a la naturaleza, está relacionado con el suelo, con el aire, con el agua, con los seres vivos. Por lo tanto, cómo una decisión o cómo este derecho del agua se une a esta nueva cosmovisión, si hay decisiones jurídicas al respecto, si hay convenciones al respecto, porque yo sé de un caso específico que está en el norte de Chile que se llama el Salar de Coposa, donde hay una comunidad indígena cuyas aguas del salar ayudan a toda la comunidad está siendo afectada por ejemplo, está siendo afectada, no es un ejemplo, está siendo afectada por una minera, la cual eh, está en cierta manera secando el salario. Entonces ellos están recurriendo a CONADI, a otros aspectos. Entonces, ¿cómo este derecho al agua cómo está vinculado a comunidades? Puede ser esta o puede ser otra.
That's another fantastic question, Claudia. Thank you. And before I answer, let me just emphasize that, right, when we think about human rights, and especially human rights law, right, human rights law by itself will not solve the difficult problems we have. But that doesn't mean it's not valuable. It can empower us, right? It can empower us to move in the right direction. And so in terms of your question about how the current frameworks are linked to indigenous communities, I would point out two main ways, and there may be others. One is the emphasis on non-discrimination, right? We know that many of these communities have been marginalized. There's a history of marginalization and discrimination against them. And realizing and recognizing that history, the current legal framework emphasizes non-discrimination, right? So if we go back to this slide on the nature of the human right to water, you'll see when we talk about accessibility, there's an emphasis on it having to be non-discriminatory. So marginalized people, they're as entitled to water as everyone else. So that's one way to approach it, to emphasize this concept of non-discrimination and equal access. But there's the other aspect of it all, where Claudia pointed out that the problem is more complex because indigenous communities have different conceptions of nature and of people's relationship to nature, which can go beyond the current legal framework, the conventional legal framework, and doesn't always fit with that legal framework, right? And so there, I would point toward a new approach that we will briefly discuss in our next session, which focuses on not on human rights to water, but on giving rights to water. Okay, so let me just briefly foreshadow that conversation without going into much detail, because we'll talk about that next class. So the current approach that we talked about positions human individuals as the right holders, and water is the object of our rights. We're going to enjoy water. Water is an object that is for us as individuals, right? It's a very kind of human-centric individualist perspective. The other approach that, again, we'll discuss next session turns this around and says, no, we should maybe think about things differently. What if we think about rights as being, what if we think about water as being the right holders? So basically what that means is that we should recognize water, such as specific rivers or lakes, as having their own rights. And some people think that that approach would better allow us to engage in environmental protection. Now, it might sound crazy to you, but there are actually quite a few countries that either enshrined in their constitution that specific bodies of water have their own rights, or their Supreme Courts have passed decisions, rulings that recognize and attribute specific rights to water. Now, again, it's not a silver bullet. There are challenges with that approach, but in terms of Claudia's question, that approach of recognizing rights to giving rights to water, such as big rivers and lakes, that is more in keeping with indigenous conceptions of nature. And often indigenous groups are actually, they play a big role in that alternative approach that I just mentioned, where rights are given to water. And of course, water itself cannot enjoy those rights, so there has to be some like individuals, often indigenous groups are involved, which try to make sure that those bodies of water enjoy certain rights. Horacio, sorry if I mispronounce your name.
Sí, buen día, mucho gusto, Soltan. Sí, correcto. Estaba reflexionando mientras hablabas y creo que ante los problemas que están comentando la gente de Chile, Alfredo también acá, yo en la zona donde yo me desempeño también, tenemos mucha dificultad de acceso al agua, me parece que una medida interesante es prestarle mucha más atención a la legislación internacional me refiero. Los países deberían prestarle más atención, porque es cierto que hay problemas económicos para llevar a cabo ciertas obras para atender a esa gente que están, por ejemplo, en el caso de mi zona hay muchos parajes donde hay pequeños poblados, pequeños parajes con poca gente que no tienen acceso al agua y es muy difícil técnicamente resolverlo. Pero me parece que deberíamos prestarle bastante más atención a la legislación que ya está escrita, internacional me refiero, para solucionar esos problemas. Entiendo que tanto Argentina como Chile tal vez se olvidan un poco de eso. Y eso, prestarle más atención, porque las comunidades indígenas, como tienen los problemas, como comentaba Claudia, tienen mucho problema. Acá en Argentina también hay ciertas comunidades indígenas que tienen los mismos problemas, ¿verdad? Deberíamos prestarle más atención, me parece, a la legislación. Eso quería hacer con ese comentario.
Thank you very much. That is an insightful set of comments, and certainly that's a challenge in some other areas as well, where there is a little bit of a distance between national and local legal frameworks and the international ones, and that is where efforts have been made to not just make sure that the national legislative bodies incorporate international law into domestic law, but also that judges should be very familiar with those provisions so that they can incorporate those and make sure that those provisions shape their rulings, right? So certainly some countries have done a lot of legal training and workshops for judges, specifically to familiarize them with the international legal framework. And then, of course, you can do kind of sharing best practices, technical expertise that can hopefully maybe also contribute to addressing some of these complicated problems. But thank you, Horacio, saying thank you. Any other thoughts about this challenge of implementation that is moving from, the law to actual practice and ensuring that that people can enjoy the right to water? I'll just wait for a minute. We have about seems like just a few minutes. So if you have any other thoughts that you would want to add, you're welcome to share. Yes, Rodrigo.
¿Qué tal? Buenas tardes o buen día. A mí me queda no la duda, o hacer una aclaración respecto de que creo que estamos hablando, cuando hablamos del derecho al agua, a un derecho a agua para consumo humano, para saneamiento, y con ese límite digo, porque acá lo que pasa por ahí en nuestro país es que se entiende como derecho a agua de que es un agua de uso indiscriminado, para llenar piletas, para regar jardines, para lavar el auto, entonces me parece que es muy interesante respecto de este tema de la legislación internacional, utilizarlo, entendiendo que creo que todo la base o el espíritu de lo que se menciona como derecho al agua para consumo humano, que tiene que ver con eso, agua para consumo, para aseo y para saneamiento. El resto me parece que tiene que ver con un buen uso y con la conciencia de parte de la población de cómo hay que darle un buen uso al agua. Esa era mi apreciación.
Thank you, Rodrigo. That's a great question, right? There has been a struggle over how broadly to define the right to water. The general comment 15 went relatively narrow, like you pointed out. There are other people who would like to broaden the scope of the right. The more you broaden it, the less consensus there is about it. And so, yes, I think when you think about what is adequate access to water, enjoyment of water, it can be sometimes contentious in terms of what you can use water for, right? We would not contest that everyone needs to have clean drinking water, but then beyond that, things can get more and more contested. And of course, when you think about irrigation, water that is needed for agriculture, you might think that should not be seen as a human right. But then, of course, the right to food is a human right, and you cannot grow food without irrigating it. So you can see that there's these connections between different rights as well, and then it becomes we face difficult problems in terms of what is sustainable agriculture, what is sustainable responsible use of water. And so those are some really, really good questions that I'm glad you put on the table. I think we have time for one more comment or question, if anyone is interested in jumping in. Well, if not, let me just thank you for your attention and thank you for your really thoughtful, insightful comments and questions. And I look forward to continuing this conversation with you next session, where I want to talk more about kind of challenges and opportunities of implementation. And then toward the end of the session, talk about this idea I mentioned, where, should water have rights? So thank you so much. Have a good rest of your day. And I hope to see you next week. Bye.
Thank you, Sultan. See you.
Bye, Gabriela. Bye,
Hasta
everyone.
luego, muchas gracias.
Take care.
Chau, chau.
Gracias, hasta luego.
Bye.
Gracias a todos. Nos vemos el martes 3.
Chao, chao.